Let's call the case of the people versus Jason Smith.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Kenneth Overwater, Assistant Public Defender, on behalf of Mr. Smith, who is in custody. State your name for the record, Mr. Smith.
Jason Charles Smith.
All right. Taking time for preliminary examination, and we're ready to proceed.
Yes, Your Honor.
All right.
It's ready, Your Honor.
And call your first witness.
Would be calling Marie Bradley, and our victim advocate has gone out and I'm going to grab her right now.
All right.
Take a seat, raise your right hand. Swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. But have a seat. State and spell your first and last name for the record.
Thank you. You may inquire.
Thank you very much for being patient with us today, Ms. Bradley. I really appreciate you being here. If at any point you need to take a break, just let me know, okay? And there's tissues to your right if you need them. Do you know a Jason Smith? How do you know him? Okay. And is he in the courtroom now? Can you briefly describe something he's wearing and where he's sitting? Your Honor, please let the record reflect that the witness has made an in-court identification of the defendant.
Record shows so reflect without objection.
I'm going to direct your attention to September 17th, 2023. Okay? Were you at 930 North Congress Street in Ypsilanti, Michigan, Washtenaw County at that time? On that date, did the defendant do something that made somebody call the police?
Yes, struck me in the face.
Okay. Can you break that down for me a little bit? How did it start?
It started because he wanted me to go in the room and leave him alone.
Where were you? I apologize for interrupting. You said he wanted you to go in the room. Where were you when this started? Outside? Okay. And what happened when you were on the porch outside?
Well, he was telling me to go outside and leave him alone. We were both intoxicated. I didn't want to leave him alone. And I don't even remember him yelling at me. He closed his fist and touched me in the nose area
On the front porch?
on the front porch.
Okay. And did he say anything else other than to leave him alone prior to punching you? Okay. Do you know how many times he hit you? Once? Okay. And can you tell me what happened after he hit you?
We just sat there, was talking.
Afterward?
Yeah. I mean, it was kind of a normal thing. So I just wiped the blood off and kept rolling.
Okay. And did you call the police or did someone else?
Somebody who had driven by had some witnessed it and
Objection, Your Honor. We're getting into either speculation, hearsay.
Well, I'll sustain the objection. Go ahead. Next.
But you did not call the police?
No, I did not call the police.
Okay. Did anything else physical happen between you and the defendant on September 17th, 2023?
No.
Okay, 1 second, Your Honor, please.
Yes.
No additional questions at this time.
All right. Cross-examination.
Thank you, Your Honor. You indicated that you and he had been drinking.
Yeah.
How much did you have to drink?
I couldn't tell you. Wow.
When you say a lot, could you be more specific?
I honestly don't remember.
More than 5 drinks?
Absolutely.
More than 10 drinks?
Probably up to 8.
What were you drinking?
It would have been whiskey and Coke,
Whiskey?
or it was my lemonade.
Well, which one were you actually drinking that day?
Oh,
You don't recall what you were drinking. Were you using any other substances?
Yeah.
Anything else? Were you using crack? So how much marijuana did you use?
probably 2-3 rolls. grams.
So you had 2 pre-rolls and at least 8 drinks.
Yep.
And those drinks might have been whiskeys. They might have been Mike's Hard Lemonades.
Right. Yeah.
Fair to say that you were intoxicated,
Absolutely.
highly intoxicated.
Okay.
So much so, in fact, that the police took you to the hospital, correct? Against your will.
Yep, I made sure that he wasn't going to jail that day.
So the police took you to the hospital because you were so intoxicated.
Right.
When you get intoxicated, does it affect your recollection of things?
Okay.
Did it affect your recollection in this case?
Yeah, up until about the punch.
So you don't remember what happened before the punch or what happened after?
Being upset that I kept following him, wanting to talk to him. Oh,
When you say he's upset, what was he doing?
yelling at me.
Okay, you testified earlier that you don't remember him yelling at you.
I don't know. Well, I mean, that's just our usual thing.
Okay. You testified earlier that you don't remember him yelling at you.
Okay.
And now you're testifying that he did yell at you.
Well, okay, I can't say whether he yelled or not, but he was telling me to go in the bedroom and leave him alone.
Okay. So now he didn't yell.
I don't remember.
You don't remember.
No.
Okay. So when you testified just now that he was yelling at you, was that untrue? Did you remember it then and forgot?
I don't know.
Did he, in the course of this incident, lock you out of the house?
I don't remember on that day when they left that house. No, I don't believe so.
No? Do you recall if you tried to break into the house by popping open the front screen door and entering the residence?
No,
You don't recall, or that didn't happen?
no, it didn't happen.
Okay,
Not that
so,
I recall. No, I have to say that, not that I recall.
okay. Do you recall if you tried to pop the screen off the back door to enter the house?
Not at that time, no.
Do you recall going into the house on that date?
Oh, yeah, in and out, beautiful day out.
Okay.
Yeah.
When you're intoxicated as you were on that day, do you ever fall down?
No,
No?
no,
No, I said ever.
no,
So when you get really drunk, you don't ever fall down.
no.
Not that you recall. May I have just a moment, Judge?
Okay.
No further questions, Judge.
Any redirect? You may step down. Thank you, ma'am.
Thank you.
Any additional witnesses for the people?
No, Your Honor.
Any witnesses for the defense?
No, Your
Motion,
Your Honor, the people move to bind over on count 1.
response.
Your Honor, defense would object. There's no evidence to support that there was anything, any injuries, there's no pictures, there's no testimony from any other witnesses to support that this even occurred. The complaining witness freely admitted she was extremely drunk. She was abusing both alcohol and marijuana at the time, to the point, as she testified to, the officers on scene forcibly took her to the hospital against her will. She is not a reliable witness at that level of intoxication. The court is well aware that it is obligated to consider the credibility of the witness, and she is not credible. I would ask the court to dismiss the charge.
Court does believe that it's an issue. It's a question of fact as to what she remembered. She clearly testified that the defendant punched her in the face, that she was bleeding. As to issues regarding her recollection of other parts of that event, again, those become, I think, issues of fact, weighing certainly on her credibility, but not to the extent that this court doesn't believe the people have met the burden of probable cause. So for those reasons, the court would bind the defendant over as charged.
Now just see to the information, waive its formal reading. My client would stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
1:30 before Judge Slade, Monday.
April 22nd, 2024, 1:30, Slay Monday. Thank you.
Thank you, Your Honor. Yeah.
Court does call the cases of the People State of Michigan versus Tamar Young, case 23 FB 1433 and 23 F2 0334.
The
Counsel,
record, the Michigan Senior Assistant Prosecuting Attorney on behalf of the people for both cases.
Good afternoon, Your Honor. Susan Longsworth on behalf of Mr. Young for the 23FB case.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Tamar Young on 23 F2 0334.
and what are we
Going to be waivers on both cases.
on
Your Honor.
both cases?
And with regard to file number 23 FB.
I'll see you next week.
That's the case that Ms. Longford representing.
Yes.
I'm just putting on notice for the court's benefit, although counsel is already aware of it, that we're going to be filing amended information to reflect certain changes in circumstances from when the case was originally filed. One,
Hold on one moment. Let them finish the conversation because I'm having,
Oh, is there feedback, Your Honor?
no, I'm hearing you while Mr. Gannett is
Sorry.
talking.
I apologize, Your Honor. Thank you, Your Honor.
Go ahead, Mr.
Ms. Longsworth and I had discussed the case over the weekend, yesterday. Count 2 is being dismissed because that was originally charged with and unfortunately, the victim on that case was a murder victim ultimately. So count 2 will be dismissed on the information, and we're adding a count 13 of open murder with Tyrese Burks being the named victim on that count.
All right.
And then when you're ready, I'll keep going through the changes that are happening.
Okay, hang on. So you're going to be adding a count 13 of open murder. Okay, go ahead, sir.
Count 2 dismissed, added count 13. Moving down to count 6, that will be, the language will be amended to reflect that it was a death to Tyrese Burks for the discharge in or out of the building causing serious impairment. That would mirror count 7 with the other homicide victim being Travis Williams, if the court follows.
So count 6, I got you. Okay, so count 6, the theory or the basis under that will change. Is that,
Sorry, that would coincide with count 5 of Dallas Williams.
yeah, okay, count 5. That, okay, thank you. All right, that makes sense.
And then when you're ready, I'll finish this off.
Yeah, no, go ahead.
We would also add counts 14, 15, 16, and 17. All 4 of those counts are going to be the same felony firearm. They're going to correspond with a felony of discharge in or at a building causing serious impairment. And essentially they correspond with the charge counts 5, 6, 7, and 8.
Got it. So 14, 15, 16, 17.
Yes, sir.
All right. So effectively, is that everything?
It is, Your Honor.
So effectively, if the defendant were to waive, he'd be waiving over on count 1, count 2 through 17.
2 is dismissed.
I mean, 3 through 17.
Yes,
Thank you.
sir. That's correct.
Longsworth, is that a correct statement as you understand it?
That is a correct statement, as I understand it, Your Honor. If I may inquire of Mr. Young.
Yes.
Mr. Young, you heard some of the changes that Mr. Ganatra put on the record pertaining to the information that they'll be filing. Is that correct?
Yeah.
And do you believe that you and I have had a sufficient time to talk about the case, talk about the benefits of holding a preliminary examination and the benefits of waiving a preliminary examination?
Yeah.
And in converse, the cons of both of those as well, right?
Yeah.
Okay, and do you understand that you are giving up your right to hold a preliminary examination, and you're agreeing that the government would be able to show probable cause of these felonies if we were to hold a preliminary examination? And you and I have talked about other evidence and possible defenses and other mitigating factors that were present. And we've agreed that those are issues that we would raise at trial if necessary. Do you agree with that?
Yeah.
Okay, so understanding all that, is it your agreement that you are going to waive your right to preliminary examination in this matter?
Yes.
Thank you. No additional questions, Your Honor.
And young man, that is what you want to do?
Yes.
Pardon?
Yes.
People also waive their right to preliminary examination, both matters. All right. And sir, you also understand, we talked mainly about case 1433. You also understand in the other case, you're waiving your right to a preliminary examination.
Yes.
All right. Preliminary examination having been waived, and let me start with case ending in 334. Defendant is bound over to circuit court on that single count. In case ending in 1433, defendant will be bound over on count 1 and then 3 through 17, as will be reflected in the amended complaint.
For my case, Your Honor, please waive reading. I can acknowledge receipt of the information. Mr. Young stands mute.
And this one,
Your Honor, we waive formal reading, stand mute, and we acknowledge that we have been informed of and will receive a copy of that amended information when it is prepared.
defendant having waived formal reading in all of the cases to all of the counts, waive formal reading and standing mute to those charges, court will enter a not guilty plea. Pre-trial in these matters will be set
April 1st at 1:30 before Judge Slay Monday.
April 1st, 2024, 1:30 before Slay Monday.
Thank you, Your Honor.
Thank you. Bond will continue as set and or denied in each case.
And I did sign the information for 334 and provided it to the court.
Yes, we do have that.
Andrew Meyer on behalf of Major McIntyre. Mr. McIntyre, if you haven't done so already, please state your name for the record.
Mazio McIntyre.
Thank you.
All right.
Your Honor, I do want to make one correction. I do note that last time we were in court, there was representations made that multiple calls were made to the victim after arraignment. However, I do believe only one of the calls was made after arraignment. That is completely my fault. I do want to note, however, I do have a full spreadsheet of all of the calls that the defendant has made to the victim since he has come into custody, not just since the 26th, but also after he was remanded by Your Honor, including 4 calls on March 7th, 1 call on March 8th, 3 calls on March 10th, and 2 calls on March 11th. I do also have an email from Lieutenant Arnett indicating that there were multiple inmates disciplined this weekend for letting the defendant use their PINs in order to contact the victim. I also have a couple transcriptions from the additional calls made between the 7th and the 11th of this month. I do want to apologize for that error with the dates. However, I do want to emphasize that our initial request for bond modification was not solely the result of the jail calls. We did feel that the initial bond being set was inappropriate because of the escalating pattern in this case, with the destruction of the same victim's property on January 7th, escalating to malabuse on January 9th, and then the actual act of physical violence that occurred at the end of February. So we were planning on making a bond argument even without the jail calls being in play.
So just so that I'm clear, and I understand what you're saying in terms of the calls, because sometimes I have to make sure that I have the arraignment as opposed to custody date when trying to assess these. But then after he was remanded this time by the court,
That is correct.
there are more calls.
That is correct. And I have a spreadsheet and transcriptions if you would like them.
Mr. Meyer.
Your Honor, thank you, and thank you to Ms. Barroso for correcting that. I mean, this was something we had discussed yesterday. I was reviewing the calls and noticed that some of them did occur before the arraignment.
Okay.
But in terms of where we are now, Ms. Barroso did make me aware of these additional allegations of calls. I don't have those yet. I only have the ones that would have occurred before the arraignment. So that's the,
So what, you don't have the calls
I don't have the,
basically from this week,
correct. I don't have those.
this past week.
Right. So I'm not in a position where I can assess what was or was not said on those calls, to whom those calls may or may not have been made to. So I'm in a little bit of a disadvantaged position in that regard. But here's what I'll say.
But those ones are new.
Correct.
Here's what I'll say. Mr. McIntyre and I discussed this. Regardless of what's on those calls, Your Honor did order him not to make any call. I think I reviewed the ROA and it said no phone privileges were revoked. So putting aside what may or may not be on those phone calls, there's a violation. He'll admit to that part of it, that he made a call when he wasn't supposed to make a call, and we'll just leave it at that.
Made a call?
Made calls, excuse me.
And that becomes part of my problem, part of my dilemma. Because at that, I mean, if it isn't clear from the magistrate and you make the calls, then once you get here, I kind of make it clear and I revoke your phone privileges and I kind of make it clear you're not to have contact. And even though I say it, write it, do that, you still just do it. And so in terms of release of this defendant, I don't know that I can trust this defendant to follow any of the court's orders regarding it. I mean, that's the dilemma that we're in.
I don't mean to pile on, but I do want to also raise one additional concern that came out of one of the jail calls, because it did appear to me from one of the calls made prior to arraignment that the defendant indicated that if he thought he was going to be in custody, he would leave court.
He would what?
He would leave court. And so that to me poses an additional concern of him not wanting to appear if he were to be, if custody were to be on the table.
I mean, in terms of ties to the community, I think I brought this up last time, and he does have a place that he was staying in Ypsilanti prior to him being remanded by the court last week. And he did have a job. I don't know if he'll be able to return to it. I was just in candor to the court, just trying to admit to what I think we can admit to at this point, which is that there were phone calls. I just don't know what the content of those calls are.
Right. And Mr. Myers, I often have to indicate to people, for the purposes sometimes of these bond hearings, certainly I'm concerned about what the content may be, but a lot of times that content is really potentially being used for what might be additional charges or other motions if the victim doesn't appear or the like. The bottom line to it, though, is you said no contact.
Right. And that I can't assess whether there was contact with an alleged victim or not at this point. I don't know that after arraignment. I don't have anything in front of me. I do have phone calls that.
Do you, so,
Spreadsheet right here to see it.
Sure. But I didn't have it until.
yeah, right.
Is this your only copy?
No, I have 3 if the court wants one too.
Just while you're also going through that, what is even more problematic is I take away the phone privileges in hopes that when we come back here, there can be at least an understanding, but then apparently he's using somebody else's PIN to potentially try to access.
They're trying to say a call. My sister.
These ones. Yes, it is.
It's 26.
It's a problem.
It's only them ones right there.
Right. It's after. Do you understand?
And Your Honor, I do want to note that some of the calls were made to a different phone number, but that phone number was referenced in a call from 3-7 to the victim's phone number as a number that would be the point of contact for the defendant to the victim. So that is how we have that information. And that is the number that the defendant was using. Inmate William McDonald, Kamani Hamilton, Rontrell Davis, and Dominic Kelly Payne's pins in order to contact. Excuse me, not Rontrell Davis or Dominic Kelly Payne. It was just William McDonald and Kamani Hamilton. He used Rontrell Davis and Dominic Kelly Payne's number or pins to contact the original phone number, just so we're clear.
Your Honor, as I said, happy to admit to the calls they make this. That's all I can admit to at this point, or have him admit to.
No, I got you. Well, and just to put it bluntly, I mean, I told the defendant no contact. Well, the court has told the defendant no contact. We restricted his phone privileges upon his remand back on the 7th of March, between the 7th and the 11th, really, but certainly within this week's period in time, he's then entered into a scheme to sort of thwart the court's order, both the original order as well as the new order that he not, that his phone privileges were revoked. So for those reasons, the defendant won't be released. The revocation of bond will continue. The defendant will stay in custody. You can bring it up with Judge Perry on his set on the 19th, so we can go from there. Thank you. He set this Tuesday for
Yes, the 19th.
preliminary.